Hello, my name is Shubhi Singh, Assistant Professor at School of Law and Legal Studies at Sage University, Bhopal. Today, I will be dealing with the topic right to free legal aid that is mentioned in Article 39A of Constitution of India. Article 39A of Indian Constitution emphasizes on equal justice and free legal aid. It says the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The legislative framework of the Legal Services Authorities Act mentions as follows. The Act was enacted in 1987. It came into force on 9th of November 1995. It establishes legal services institutions at national, state, district, and taluk level. It also mentions eligible categories for free legal services. The following is the organogram of legal services authorities or committees in India. We have national level NALSA, we have state legal services authorities, we have district legal service authorities, and we have taluk levels committees. The presence of legal aid institutions are as follows. State Legal Service Authorities 37, Supreme Court Legal Services Committee 1, High Court Legal Services Committee 39, District Legal Services Authority 672, Taluk Legal Services Committees 2282. The key programs provide legal aid and assistance, to also run outreach programs, to also conduct Lok Adalat and mediation, to promote alternative dispute resolution mechanism, and to run victim compensation schemes in order to rehabilitate the victims of crime. Constitutional and legal framework for providing legal assistance at early stages. The following are some of the mandates. Right to life under Article 21 of the Constitution of India, Article 22, Section 12 of Legal Services Authorities Act 1987, Section 41D Code of Criminal Procedure. The following are some of the important judgments Supreme Court has given in lieu of the right to free legal aid. M.H. Hoskett versus State of Maharashtra. The court held the right to free legal services was recognized an essential component of procedural justice. In Khatri versus State of Bihar, the court stated that it is a constitutional obligation to provide legal aid not only when trial commences, but also when the accused is remanded from time to time. The early stages of legal assistance are as follows: pre-arrest state, arrest stage, and remand stage. The objectives of early access to justice are as following: to provide legal assistance to needy, to assist in avoiding unnecessary arrest, to decrease the vulnerabilities, and to assist the arrestees in filing bail applications and furnishing bail bonds. Features of legal aid to person in custody. 7 categories, including prisoners in custody, women, and children, are entitled to free legal aid irrespective of their income. Judicial officers are manning legal service institutions. Legal aid is available in police stations, trial courts, as well as in appellate courts. Available on all days, including holidays. Last, government gives the entire budget for legal aid programs. Following is the 5-point strategy for providing legal aid at early stages, which includes spreading awareness, training of legal aid lawyers, sensitization of police officers, ensuring quality of legal assistance, deputing male and female lawyers as per the perceived requirement. Role of state legal service authorities, challenges in implementation, timely information of suspects and arrested person, hesitancy on the part of suspects to avail legal assistance, providing of legal services at odd hours in hilly and remote areas, and monitoring challenges in monitoring progress of every case. quality assurance measures. There should be proper training, monitoring, performance standards given in NALSA's protocol should be followed, proper documentation and reporting should be there. Other supportive methodologies include legal aid clinics in prisons under trial review committees and regular visits of legal aid functionaries. The way forward. Future strategies are as follows: frequent consultations among legal services authorities, enhanced capacities of legal service providers, improved coordination between legal service authorities, improved monitoring over services provided, sharing experiences, strengthened documentation and reporting. That's all, folks. Thank you. Stay tuned and subscribe to Sage University Bhopal.